Hello, I'm Hector McQueen of the Scottish Law Commission, and I have led in our contract project, which has now produced this report on third-party rights in contract. A third-party right in contract arises where two or more parties conclude a contract which contains provision in favour of a third party. As this diagram shows, one not otherwise directly involved in the contract's formation. And the contracting parties intend the provision to be legally enforceable by that third party. The Scots law on third-party rights, for which the Latin tag jus quaesitum tertio is often used, is currently found in the common law. And this means that it's largely been developed by legal writings and court decisions over a long period of time. And unfortunately, the law has become unclear and in need of modernisation. One major hurdle is that to exist at all, a third-party right must be irrevocable from the outset, i.e. it can't be cancelled or modified by the contracting parties. And this requirement is seen in commercial life and elsewhere as too formalistic and inflexible, and it's a barrier to the practical value of third-party rights under the current law. Left to itself, the common law can only be changed by a decision of an appropriate court. The leading case on third-party rights and irrevocability in Scotland was decided in 1920 in the House of Lords. Under the doctrine of precedent, therefore, only a decision of the Supreme Court can change the law, and of course only if a suitable case arises, with parties prepared to fund it all the way. The alternative is to introduce a modern, clear statute dealing with all the issues in a way not possible in any single case. This is the approach taken by a number of other jurisdictions in recent times. The Contracts Rights of Third Parties Act 1999 in England and Wales, which introduced third-party rights for the first time south of the border, has inspired legislation in, for example, Hong Kong, Singapore, and some Australian states. New Zealand introduced third-party rights as long ago as 1982. Amongst non-English speaking jurisdictions, which in contrast have, like Scotland, long recognised third-party rights, the 2016 revision of the French Civil Code also contains an overhaul and clarification of the laws relating to third-party rights. Now, Scotland differs from other English-speaking jurisdictions in already having law on this topic, but it has fallen behind the emerging international standards. In particular, in none of these English-speaking systems, or in any other, is there any requirement of irrevocability. This is the background to our project. Based on responses to a discussion paper published in 2014, we have come up with a set of recommendations for full reform of this area of law. They are given effect in our draft bill, whose central objective is to clarify when a third-party right can and cannot be modified or cancelled. This diagram from page 73 of the report shows the logic of our scheme in a flow chart. The present precondition of irrevocability, which creates most of the inflexibility in the present law, is removed. Instead, the parties to the contract are to be permitted to modify or cancel the third-party right unless certain circumstances spelled out in the Act prevail. First, conditions upon which the right depends are fulfilled. Second, the contracting parties notify the third party of an unconditional right. Or, third, the third party relies on the right and the contracting parties acquiesce or ought reasonably to have foreseen those acts of reliance. Parties can also provide that the right is irrevocable should they wish to do so, but equally they may contract out of any or all of the rules just mentioned should that be their preference. Flexibility is the key. The bill also clarifies a number of points on which there is currently an absence of judicial authority. That is, third-party remedies, such as damages, defences against the third-party claim, third-party rights in arbitration, and prescription. In certain circumstances, there is the possibility of working round the current inflexible rules. For example, make the contract multi-party, including the third party. Or again, one of the contracting parties gives the third party rights by a separate transaction, often called a collateral warranty. This is quite common in commercial developments, to give rights to purchasers and tenants of units within the development in respect of faulty construction or design. Or finally, make the third party right provision subject to another legal system, such as the 99 Act in England and Wales. But multi-party contracts and collateral warranties are not available as solutions within the present legal framework where the third parties are non-existent or unidentified or otherwise incapable at the time of contracting. Examples of non-existent parties include companies which have not yet been formed at the time the contract is made, the ultimate purchaser or tenant of a commercial development, or the subcontractor to be appointed during a project is usually unknown when the construction contracts are signed. Application to third parties whose specific identity is not known at the time of contracting is a key practical application for a third-party rights framework. Under the bill, it's possible to create a third-party right in favour of a party who is not in existence at the time the contract is created, without the provision then falling for uncertainty. In this case, of course, the right comes into full existence only with the person. Where the specific identity of the third party is not known at the outset, the third party may be described in the contract in such a way that the right crystallises as soon as a specific person or persons meeting the description emerges or is identified. There is no need to scramble around post-project completion, creating collateral warranties, or getting the now identified third persons to sign the original contract. This bill is general in its application, and it's not confined to any particular sector or group. So a wide range of people and businesses can make use of it. In business, we think it will be particularly useful for company groups and in sectors which rely heavily on contractors and subcontractors. And again, where projects involve many parties in complex formal arrangements seeking to allocate risk efficiently between them, e.g. construction, shipping, energy, pension schemes. But application goes beyond the commercial or business sector. Private individuals may also benefit from the new provisions. For example, where they go on family holidays, buy houses with the help of relatives, take out insurance for the benefit of other family members, or make contracts as part of their informal caring for an incapable adult. Scots law in this area went askew almost 100 years ago. The Scottish Law Commission is delighted to make recommendations to bring it up to the expectations of the 21st century.